Thank you, everyone, for being here. Thank you so much to Proskauer for generously hosting this. I'm really excited about this room, and it's great food. Thank you also to the State Bar and the National Council of Juvenile and Family Court Judges for co-hosting this training. And finally, I want to thank the Legal Information for Families Today, or LIFT. I just want to invite Kathy up very briefly to say a few words about LIFT before we get started. Mm-hmm. I'll just bring that on.
That's all right. I should have been up here. Good afternoon, everyone. My name is Kathy Kramer, and I'm the new CEO of LIFT, Legal Information for Families Today. And I just wanted to tell you what LIFT does very briefly, because we provide legal information in family court in the 5 boroughs of New York City. We have a lawyer in each court, and we run sort of a help desk in the morning on the issues of child support, custody, visitation, and some domestic violence work. And we see anybody and everybody who comes into family court. We often have a long line at our help desk. In the afternoons, we do more intensive meetings with litigants who have more complex issues, and we call them our family legal centers. And the exciting thing is that we're able to work with over 30,000 litigants a year, because we're not doing representation, we're just doing legal information. But going forward, we're expanding our mission a little bit. We're going to start providing some legal advice, which as lawyers, we're very excited about. And then we're also going to be doing some really interesting pro bono work, building off the success of the volunteer attorney program, where we bring attorneys, the court brings attorneys down to the courthouse to work with litigants in a family legal center type of situation. We're now going to start to use technology so we can get more pro bono services. Does this sound, I mean, this is a lot of feedback. Anyway, more pro bono services to litigants in family court by using technology, and we're developing a platform with Pro Bono Net. And so we're going to be rolling that out in the fall. And I know many of you are from law firms, so we'd love to work with you once we get this system up and running. And it's all on the topics that you seem interested in because you're here. So obviously child support is a huge part of our work, and we're so happy to be supporting this training and working with organizations like Her Justice to get more and more support in the family courts on these issues. So I hope you have a great training, and thank you, Proskauer, and I'll turn it back to you.
Okay, thank you. So just a couple words about Her Justice. I don't want to take up a lot of time because we have some really great speakers to talk to you. As many of you may know, Her Justice is an organization that works with low-income women in New York City and their children. And we partner with law firms and other corporations to provide pro bono services to women in the areas of family, matrimonial, and immigration. So I just want a quick show of hands of who from Her Justice is here. Can we have staff? I know we have a lot of staff. Hi, guys. And then do we have any Her Justice pro bono attorneys here? Great, thank you. Externs? Anyone who's taken a case from Her Justice before? Okay, great. Thank you all for being here. This is an advanced support training, so we do assume some basic child support knowledge. So we're going to assume that you know about the child support formula and some basic things about family court. What we're going to be talking to you about today is a deeper dive into some of the more advanced topics such as discovery, imputing income, and enforcement. I have put some index cards on everyone's table. So this is, we're planning to have a longer Q&A session at the end of the program, but if you think of questions as the program is going on, feel free to write them down on the index card. We have Martha and Naomi here in the middle who are going to help me. If you have a question, just sort of wave your index card and they'll come around and collect it and bring it up to me. And I did not introduce myself. My name is Anna Ognabeni, and I'm a senior staff attorney at Her Justice. I was so excited to introduce everybody else, I forgot myself. And with that, I will introduce our illustrious panel today. So we have Yira Zhu, who is here from Kroll. She's the Associate Director of Investigations and Disputes. She's a certified public accountant and a certified fraud examiner, specializes in complex financial investigations, public company regulatory filing review, public record searches, construction monitorships, and business intelligence investigations. It's a really impressive list. In particular, why she's here today is that she's also a strong supporter of our work at Her Justice, and we have partnered with Kroll on many child support cases where the respondent's income was either unknown or underreported, or in cases where the respondent maybe should have been working but was deliberately not working to avoid his child support obligations. Yiro has been really instrumental in a few complex cases. She served as a forensic accountant and an expert witness in some of our cases, and so we're going to ask her to talk a little bit about that work. And then to her left, we have support magistrate David Kirschblum, who has been a support magistrate since 2000. Before that, he was a senior attorney and then the head of the matrimonial and family law department at Gorlick, Kravitz, and Listhouse, PC. Pardon me, you were appointed to the family court bench in 98, but started hearing child support petitions in 2000. Before that, he was doing public assistance cases where the children were receiving public assistance. At first, he started in New York County Family Court. He's presided over many celebrity cases, including the matters of Mick Jagger, Al Pacino, Harvey Keitel, Sean Combs, and Wesley Snipes. So hopefully he can describe some of those. And then in July 2003, he transferred to Queens County Family Court, where he currently sits and hears approximately 25 to 30 paternity, spousal support, and child support cases per day. So we're really excited to have you both here, and I want to dive right into the program. So the first section of our program is going to be about finding and imputing income, and I want to start with Yiro. Maybe, Yiro, you can just tell us a little bit about what you do as a forensic accountant and how you can help attorneys doing support cases.
So forensic accounting is really, I'm sorry, I'm a little short for this mic. Forensic accounting, broadly speaking, is really just the application of our financial and accounting expertise to the review of available records, and also filling in the gaps where your information may be insufficient to formulate a certain opinion or determination as to what assets or income somebody has in a divorce scenario. And I think with respect to child support, that it really is no different from my perspective in determining income base, whether it's a child support or a matrimonial support case. We really just look at the records that we work with you to look at the records that you have obtained through discovery, and we can often impute income from what seems, from your perspective at least, to be very, very incomplete records.
So when the income is actually there but unreported, so for example, it's off the books or he's getting a lot of cash, what kinds of things can you do in a case like that?
Well, I guess can I speak to specific cases that I've...
Of course, yeah, please.
So I worked on one case pretty early on. It was my first case with Her Justice, and I believe the counsel was White and Case. And the adverse party was a livery car driver. He was reporting something ridiculous income-wise, like $15,000 a year or something like that. And it was completely inconsistent with the lifestyle that the wife described that they lived. And he had a few kind of public record ticket items because Kroll is an investigative firm, so we always do a cursory background on all of the adverse parties before I start any sort of forensic accounting analysis. And there were some things that just didn't jive with his reported income and what I was seeing in the public record. So he had a home with an accompanying mortgage that he could not have afforded on $15,000 a year. He had a brand new Acura that was leased, and Acura would never give somebody a lease who makes $15,000 a year for a brand new car, things like that. So I had reason to substantially doubt what the adverse party was declaring. And counsel provided to me, so there are different things that are in different industries, regulated and unregulated, that you can actually find from public record and a combination of discovery. So in this case, they had subpoenaed the ride receipts of this person's livery car activity, I suppose, from the Taxi and Limousine Commission going back about a year or two. And they were very incomplete. They didn't have any mileage or fares or anything that you could directly determine income from, but what they had was pickup times and addresses. So I basically just created a relatively simple Excel model where I picked up all of the pickup times and ignored the addresses, and I made certain assumptions based on available economic data about earnings of livery car drivers in the New York area, inflation, average ride times, ride lengths in New York City. And I created a model where I made certain assumptions that every pickup time that was less than 15 minutes apart represented a contiguous period of work. Everything more than that represented a ride that lasted at least 15 minutes. From that, I calculated the number of hours worked in a 4-month period, which is what we had data for, annualized that, and then I applied an inflation rate. I calculated those hours, and then I calculated the annual earnings, gross earnings, based on those hours, and then I took that from 2014, I think is when I had the data from, and then inflated it to today. So from that, I was able to determine at least a reasonable estimate of income from very, very incomplete data.
That's really fascinating. And was that number accepted by the support magistrate as the income?
So that case was actually really interesting. One side of the child support proceedings that I never see because I've never looked at is the needs-based formula on which support can be determined. And once I gave my opinion of income to counsel, they determined that the needs-based formula actually produced a more favorable number for the client, and that's what they used in that case.
Mm-hmm. Magistrate Kirschbaum, I'm just switch to you for a minute, and if you have any reactions to that, if you were in a courtroom and someone came with an expert report on a livery cab driver with that, I mean, how would you treat that?
So first of all, I want to, can everybody hear me over there? Good. I want to thank Anna for inviting me, and I certainly want to show my appreciation in not only attending, but to recognize the hard work that her justice does. Your participation and your activities make the court's job easier because litigants who are coming in already emotional, who have someone, an advocate who can speak on their behalf, makes things a lot easier for the court. My first experience with her justice was actually many years ago when an attorney came in with a whole group of collegiates. Her name was Maria Arias, and several years afterwards, I was very pleased to receive a letter from the mayor's office asking for my position on her candidacy as a family court judge, which I certainly gave her a glowing recommendation. And the work that I've seen of her justice is amazing. Insofar as the question, so I've now been in Queens for approximately 10 plus years, and certainly in Queens we have a lot of these cases with unreported income. You have to remember that in New York City we have 2 airports, and both of those airports are located in Queens. And so as a result, we have many employees who either are W-2, but then there's a lot of tipping. I don't know if you've traveled and if you've ever curbside checked. I have a lot of litigants who are curbside porters, and they seem to have no problem, and I'm not suggesting that they're perjurious, but we don't receive tips at the curb. Now, I don't know what I've given my luggage. I certainly want to give a little bit of a tip because I'm concerned about the safety of my bag and the arrival of my bag, but it seems that everyone who's come into court has never tipped or has never been tipped. We have a lot of taxi and livery drivers. We have a lot of barbers. So certainly we see these types of cases with a lot of unreported income. I'm not suggesting Queens is specific. In New York City, you see it quite often. So what are the 2 alternatives? Obviously, what Ms. Yeru does is quite helpful in being able to assess and to review and to make determinations based on personal returns, corporate returns, spending habits, financial disclosure affidavits, and the listing of expenses. Some are actually quite proud to list a lot of expenses thinking that they're going to receive the sympathy of the court, and yet when it comes to their actual reported income, the income is a fraction of it, which certainly gives rise to the immediate question, well, if this is all you're earning, how can you possibly be spending all this kind of money on expenses? They don't think about that. Until they're questioned. And then, of course, they receive money from other sources, which under the statute is also income that can be utilized for purposes of calculating child support, and the imputation of such income can be utilized towards the Child Support Standards Act. But as an alternative, as Yeru suggests, if we cannot make a determination of one's income, then it's always helpful, pursuant to Family Court Act Section 413(1)K, to utilize a needs-based order and to take testimony as if the respondent is not even there as an inquest of exactly what the needs of the subject child are, and then to utilize that in determining an order of support. So the statute is helpful in those situations where we can't really determine one's income and utilize a different formula. Then we ultimately have those situations where people can't afford it, and we have violations, which we'll get to later. But for purposes of a establishment case and an order of support being entered, the determination of forensic accounting and the help that it would give a court in understanding what one's true income is always helpful.
Thank you. Yira, back to you. I was hoping that you could also talk a little bit about some work that you might be able to do helping attorneys where the suspicion is not that he has actual income that's hidden, but when he really ought to have income based on what he's able to do, but may be deliberately under or unemployed.
Sure. So I had another case where the adverse party was in the construction industry, and he had a specialized construction trade. So let's just say, for argument's sake, that he is a plumber. And I work on construction monitorships and construction fraud cases on a billable basis at Kroll. So that gives me some insight into kind of what the market looks like for certain trades within the construction industry. And the discovery in this case that was provided, also incomplete and relatively unreliable, this was an individual who was self-employed and claimed that he made X number of dollars a day in a skilled trade, which was completely inconsistent with what I and my colleagues understood the market to be for this trade. So in that case, and then there was also the issue that his work log reported what annualized to be approximately 32 hours a week of work, and this person had no injuries or known disabilities, and there isn't really a glut in the market for what he did that I was aware of. So basically, there was no reason why he shouldn't be fully utilized and fully employed. There was also the issue that this person worked part-time as supposedly, or he asserted that he worked part-time as an unskilled laborer and part-time in the skilled trade. So I provided counsel with an opinion in two hypotheticals, one under which I accepted the number of hours and days that he was working, as well as the allocation of his labor between unskilled labor and the skilled trade, what I thought he was truly making, if I accepted those to be true and simply didn't accept his daily rate in the skilled trade. And I got that daily rate from just doing market research, economic research, and also using our sources that we, Kroll as a firm, have within the construction industry, having been in the business of monitorships and fraud investigations for many years. So that was my estimated actual income number, and then I also provided counsel with a number with two additional hypothetical numbers, one assuming full-time, full utilization employment at 40 hours a week with 2 weeks of vacation and 2 weeks of holidays, national holidays where people wouldn't work. And then another one, so one with that calculation, assuming that he was doing his skilled trade full-time, which I would imagine somebody would want to do just from a behavioral perspective, right? And another one, assuming that he really out of need or desire or whatever the cause may be, actually split his time, 70% to the skilled trade and then 30% to unskilled labor, but still working full time. So I presented two hypothetical numbers to counsel as well.
And did you know what the result was in that case that you helped with?
Actually, I don't. Sorry.
Magistrate Kirschblum, if that had been presented in your courtroom, how might you have considered that report, and how do you assess an attorney's contention that a father is underemployed or ought to be working full-time?
So certainly there is statutory authority to presume that one has the ability to work full-time. And for someone who's documented, it's a lot easier. And so as a result, when we have documented litigants, someone who comes into court with a employment history, but then immediately upon being served with a petition, all of a sudden it is out of work, we can certainly utilize their prior incomes for purposes of an imputation, and that income would be utilized to the statute and the application of the formula. For those who come in without that work history, it's a lot more difficult. And for those who have income, but the income is not documented in the traditional manner, even more difficult. So we have a tier test. We have those cases for which we have W-2 employees, easy. Obviously, if the income is quite large, then based on Cassano considerations and the $143,000 application, could become complicated. And that's where you have these lengthy proceedings with regard to high income cases. But conventionally, the W-2 income is the easiest. Then you have the 1099 income. And the 1099 income is a little bit more difficult because then you look at the Schedule C. And there's a lot of creative accountants out there. There's a lot of also creative agencies that do a lot of things. I'm always interested when I look at the Schedule C, or actually the second page of the actual tax return, to look at who prepared the return. And sometimes it doesn't say CPA, it doesn't say PC or some other legal corporation. It actually says travel agency or some other type of business, but they're multitasking and they're doing tax returns as well. And then when you ask the litigant to explain the Schedule C, and do they have any documentation to support any of those expenses, of course they have no idea what I'm talking about, and they certainly say, well, I gave my receipts to my accountant, they prepared it. And then you suggest, well, if you want me to believe it, then be prepared to bring in your accountant. And inevitably, that rarely, if ever, happens. But it's still complicated. And then, of course, you have the cases in which someone is not reported at all. There's no 1099, there's no W-2. And for those, even more difficult. So certainly, based on those types of situations, for an expert such as you to come in and to present an illustration is very helpful. You have to also understand that as a jurist, we should be looking at these cases not in a bubble, but we should be looking at them individually. And so therefore, as much as we might have certain types of people of similar ethnic backgrounds or alternatively with similar vocations, every case should be dealt with individually. And that which we've learned from one case, we shouldn't utilize our own independent knowledge as our own expert, even though we're also the determiner, the trier of fact. We should make the determination based on the evidence, which leads to a different complication, especially because child support, unless you have pro bono or private counsel, oftentimes you have unrepresented litigants. What is the purpose and what is the line that a jurist has in making the determination as a trier of fact, and when do they become the, if not prosecutor, the one who inquires? And how hard do you inquire? And how much information do you have when you, or do you seek on behalf of the interests of justice? Because ultimately this is about children's needs of support or rehabilitative support for spouses. And to that end, we have to walk the line very carefully. Do we ask questions? I certainly can speak for myself and say I do. I want to know the truth. I want to get to the truth. I want to understand exactly why someone suggests that they have the expenses listed on a financial affidavit but no income to back it up, or the alternative, their income is so disproportionate with their spending habits, or that they have a W-2, a 1040 form with a Schedule C that has a gross receipt of a six-figure number, but they're left with $8,000 as their income on their 1040 form. Doesn't make sense to me. And ultimately, as I oftentimes do, if someone is going to come into my courtroom and show me such a tax return, my answer is minimum wage hopefully is going up further, but at the very least, show me $400 worth of income. Show me $20,000 per year in income. When you're going to show me $8,000, $10,000, you're going to tell me that you're working full-time, what exactly are you doing? And why are you doing it? And just because you say it doesn't mean I'm going to accept it. And just because the Internal Revenue Service and the New York State Department of Taxation have not audited you and sent you somewhere that you probably should be, doesn't mean that I have to accept it. And so ultimately, my function is to get to the truth, if at all possible, and therefore the function of an expert insofar as leading me to an understanding from the perspective of one side is helpful. Now, obviously, we then encounter a different problem. So let's say that a determination is made based on that the respondent's representation of income is not credible, and we utilize the experts for purposes of entry of an order of support. We will ultimately, and you have to remember that child support is a nuance. As I constantly say, I have one of the most experienced family court judges sitting to my right, Judge Stephen Bogash. He's been doing juvenile delinquency cases. He writes on juvenile delinquency cases. He's an absolute expert on the field. And I constantly, after talking to him about our New York Mets, I also talk to him about the difference between JD cases and child support cases, and that ultimately you'd like to think that he will see respondents once and they'll rehabilitate and they'll become adults, and then hopefully they won't end up in another court. With us, you have to remember the big picture. When we have litigants who are coming before us and they have children who are 2, 5, 7, 10, the statistics are there to show they will be back in court, whether it's for an upward modification, a downward modification, an enforcement petition. So there has to be some practicality. And as a result, when there are orders that are entered that can't possibly be paid because we are looking away from the respondent's income and imputing something that's possibly reasonable in the custodial parent's mind, doesn't mean that ultimately it's going to get paid. So there's a big picture here. And the line is you want to make sure that the orders are going to be enforced. When someone receives an order that they can't possibly pay, and I've had litigants who have come into my courtroom having paid zero with this simple explanation, I didn't know that the support collection unit would accept less. So if the order is $250 per week, but they were able to pay $75 per week, what's the inevitable result? They pay zero because they just don't pay the $75 per week. And so as a result, we look at the specifics of the case, and I certainly can say that ultimately I want my orders to be enforced, and I want them to be complied with. I don't want for this to be a parade where constantly, in legal terms you have these Latin words, res judicata and collateral estoppel. And they're applicable in family court proceedings and certainly in child support proceedings. But oftentimes, people file a downward modification because they say they can't afford the order. They don't have evidence. We have a hearing. They can't make their prima facie case. What's the first thing that they do? Do they go home and try and figure out their life and make a better circumstance for themselves where they could pay the order? No, what they do is they walk out of the courtroom, they go right downstairs to the petition room, and they file again because ultimately the dismissal was without prejudice. So we're trying to do practical things. And for a custodial parent, mother or father who's working, the impact on them having to constantly be coming back to court because they've been summoned once again for a downward modification also is contrary to their interest and the interest of the child. We don't want custodial parents losing their job because they have to constantly come to court. So ultimately, it's a balancing test. We want orders that are appropriate and sufficient to maintain and to provide for the children and for the spouses who need. But we want orders that are also practical. Sometimes I inherit cases in which the jurist is no longer in the county or they've retired, and I see the order and I realize this order is just not going to be complied with. And so therefore, on a downward modification petition, I try to use practicalities, obviously subject to the case law. If someone has quit a high-paying job because they've decided to relocate, they want to live in a more scenic city, and therefore they've intentionally reduced their income, that's not a basis to lower an order of support. So the statute has to be complied with, and the case law has to be complied with. But these unreported cases are difficult. And ultimately, we want to make sure that orders are enforced, orders can be paid, and custodial parents don't have to constantly come back to court repeatedly so that they have to answer a petition.
Ira, I want to turn back to you one more time on the subject of imputing income and ask you to talk to us a little bit about what you can do in terms of asset searches. So you talked a little bit about imputing income based on how many hours someone might be working and what they would be earning. What can you do in terms of finding assets to show that someone may be earning more than they say based on their ability to have these high income assets?
As I mentioned before, Kroll is a full-service investigation firm, so we have people who specialize in everything from e-discovery to source inquiry, surveillance, business intelligence searches, and public record searches. So I usually tend to start with public records. So I am trained as a forensic accountant and a private investigator. So I like to start all of my her justice or high net worth divorce cases the same in terms of a basic public record asset search to get a sense of somebody's lifestyle and what's out there in social media, what kind of property, real property, vehicle registrations they have. We can run DMV searches certainly in New York, in certain other states as well. We have access to pretty much the same commercial databases that most of the attorneys in the room have access to, Lexis, Westlaw, Bloomberg, and these things can be very, very instrumental in determining lifestyle and expenditure and certainly corroborating or refuting any assertions made by the adverse party on an FDA. Is that what you were looking for?
We had spoken about a case that you did specifically where you had found some luxury cars. Do you mind talking a little bit about that? Yeah.
So this was an interesting case, actually, to respond to Magistrate Kirschblum's earlier point about W-2 income. So this case was very interesting in that the client believed that her husband actually owned a business also within the construction industry, and it was also a specialized trade business. And he claimed that he was an apprentice, had no specialized skill or training, and that he was an employee, and that he also made something ridiculous like $10,000 a year. We ran a DMV search and found that over the last, I don't know, maybe five years, maybe the relevant period of the divorce, that he had owned a series of relatively nice cars. There was a BMW 740 in there. There was like a 2011 Nissan Pathfinder that he bought in 2010 and was paid off according to his own declaration in the divorce filing. So things like that. And then he also owned a home on which there was no mortgage, is somewhere in the 5 boroughs. So those were some of the things that we surfaced in public record searches. We've worked other high net worth divorce cases and asset searches for collection of judgment on billable matters, where social media has led us to certain assets that somebody has transferred ownership of to relatives, friends, etc. So all of those things can be pretty helpful.
Thanks. Magistrate Kirschblum, you've already spoken pretty eloquently about some of the ways that you assess the credibility of reported income, for example, when their expenses or perhaps their very high expensive luxury cars outweigh the reported income. So I guess what I want to move to is to ask you then about your perspective on conducting discovery, because many of our volunteer attorneys working with Her Justice are, of course, super excited to do the best job for their client and are really excited to zealously pursue some of these discovery devices that Yeru and Kroll might be able to help us with. I'm curious on your perspective on how you view discovery, when you think it's appropriate, when it might cross the line into you feeling that it's too much, a fishing expedition, and also if you can speak a little bit to whether that opinion of yours changes if the other side is unrepresented versus has counsel.
So certainly Queens County is different from my experience when I was in Manhattan. It's rare that in Manhattan people are commuting to the courthouse by car. We do have garages, though, right next to the courthouse in Jamaica. And quite often, the petitioner is, after hearing the testimony of the respondent, he has no income, or she has no income, or they have limited income, tells me, but he drove here. I saw him in the garage, and his car is over there. And I'll recall the case, and I'll keep the respondent in the waiting area, and I tell her to use her phone and to go over to the garage and take a picture of the license plate so that I could see it. Now, obviously, that's not dispositive, because ultimately he or she can tell me that they borrowed a car, and they borrowed it for the day from their mother, their sister, their Uncle Jack, or someone else who happens to provide. Nonetheless, people's lifestyles, their spending habits, these are things that certainly I will utilize. So when it comes to the statute, and specifically 424A, it's very specific. There are 3 documents that every case you have to come to court with. You have to come with a W-2, a tax return, and a financial disclosure affidavit, and a recent pay stub. But certainly for those who do not have that conventional job, no W-2, no pay stub. Oftentimes the tax return hasn't been filed in many, many years, or it's unreliable, and the financial disclosure affidavit says minimal insofar as expenses, or, as I said before, disproportionate with their alleged income. So I'm certainly amenable to hearing not only their representation, but then the petitioner, who oftentimes is pro se, the rebuttal evidence. So social media has done wonders for people being able to come to court with all kinds of fancy pictures. Pictures of people who are behind the wheel of a car and posting themselves in such. Or I constantly see pictures of people who do this fan thing with the bills, and they're always hundreds, and they take a picture of themselves and post it. And of course, the petitioner says, how can they possibly post all this money? This is more money that he alleges to earn in a whole year, and yet he's posting on social media that he has this, or the fancy vacation that they took. So there are certainly issues of admissibility, and I don't want to suggest that I do everything the same as every other jurist, but I certainly, because I am not only the jury, but I'm also the judge in these cases, and therefore I have to determine the evidence, its admissibility under the CPLR, as well as its credibility. And of course, oftentimes people are telling me, especially if they are not in a conventional job, well, I have to demonstrate on social media, because I'm an up and rising rap star, that I have this type of asset, even though it's actually not mine. It's all of Assad. And as a result, if I come there and I show a beat-up 1998 Toyota Corolla, not that there's anything wrong with having that, but it's not going to reflect on me as well as if I'm behind the brand new red Ferrari, even though, of course, I don't own a brand new red Ferrari. So it's a question of credibility, and it's a question of ultimately being able to make a determination based on what's provided. When someone has a litigant, an advocate, an attorney who is well-versed and the other side is not represented, I allow the attorney for the petitioner to go forward. I allow them to make the record, and I look at the respondent and I say, very simply, I am not yet ready to make a determination. There is a process where you can order a transcript. Would you like an adjournment? You can order the transcript, show it to an attorney of your choice, and then be ready to come back to court and give me your side of things so that ultimately they have their opportunity to defend. And if they choose not to, then of course I have the ability to impute that circumstance or that evidence as additional income. Now the statute is not limited to 424A. In the court's discretion, there's also 4131J, which allows for broader allowances of discovery, corporate returns, and other types of evidence. I use it, but I use it when it's purposeful. When attorneys are providing pro bono services, the ethics are clearly there, and I don't want to suggest any wrongdoing on any attorney. I see some attorneys who appear before me in private cases as well. I assume ethics in all regards. But sometimes when you have higher income cases, the amount of time that attorneys are ready to litigate, especially if they're not going to be awarded counsel fees, could be contrary to their client's best interest. And so therefore, I have to keep a little bit ahead in realizing, is this a fishing expedition? Is this a way for an attorney to look to try and bill a lot of hours and ultimately feed their own pockets instead of what's really at issue here, which is providing for the children? Every dollar that is being spent on discovery, every dollar that's being spent on trials could be a dollar that could be used for the children. And oftentimes I say to both litigants, because ultimately there's a goal, and they're absolutely adverse one to the other. Every petitioner wants me to give them $1 billion. Every respondent wants me to issue a $25 per month order. So there's a lot of room between those two. And as a result, what do? Well, I certainly am not going to split the difference. But I'm ultimately going to try and look at the big picture. And if I see that there are attorneys who are looking to try and pursue unnecessary litigation or unnecessary discovery, I'll rein it back to just 424A, those 3 documents, or in the alternative to something else. One other device that I've used, which is quite helpful, because it seems that unless you were born in this country and you've stayed in this country, everyone has a passport. So I do adjourn matters and I ask for passports, because if I'm going to be able to see that you have traveled abroad, then it bears a question. Now, ultimately, what is the most popular answer I get to why people are traveling, especially to certain beautiful locations with beautiful blue water and islands? Well, I had a death in the family and I had to attend a funeral there. Well, you were there for 2 months. How long was the funeral, and how long was you providing your sympathies to the family? So it's a helpful tool. Every jurist has their own methods and strategies, and one that I like to utilize, especially because we have in Queens County such a diverse population. One of the things that I had to become acquainted with after doing a lot of cases for the first half of my career doing these child support cases in Manhattan was to learn the population of Queens County. I recently understood from the head of the interpreter office that there are more interpreter language cases in Queens County than anywhere in the world, because you have people from every corner of the world coming and ultimately settling in Queens County. And so as a result, there were languages I wasn't even acquainted with that I like to hear, because it's just fascinating to listen to the interpreters interpret the words into English and back to the litigants based on what I'm or the attorney saying. But ultimately, there's also that cultural idea. There are people who are subject to this process who culturally do not understand the responsibility of both parents providing for a child. And therefore, they believe that when they come to court, that it's no different than coming to the IRS. I want to pay as little as possible. How can I pay as little as possible? And so therefore, it is a balancing test. And therefore, when it comes to these unreported income cases, there's ultimately a child to be supported. And we don't want these children ending up on public assistance. And so as a result, we want to make an order that's appropriate and an order that's fair.
With regard to expert witnesses in particular, on the topic of discovery, how active of a role do you take in questioning an expert witness, for example, when the other side is unrepresented? So you mentioned that if one side does not have an attorney, you offer them an adjournment to go and consult with an attorney and come back and offer their own proof. Do you take an active role in cross-examination of experts, or do you ask your own questions if the attorney is not there to do it?
Yes. I have a background with economics and accounting, and once again, it's that line that you don't want to cross. You never want to appear to litigants to be on the side of one party. That's not the function. We're ultimately supposed to be impartial, but we also are fact finders, and we are the trier of fact. We're making determinations, and accordingly, if we can't understand and we need clarification, it is appropriate for a jurist to ask a question, or more than one question. Well, will I be more active when the one side is not represented by counsel? Absolutely. But after giving the other side the opportunity to ask a question. I sometimes adjourn matters, and I recommend to people to watch TV. And I don't mean watching some reality TV. I'm talking about watch Judge Judy, who happens to be the first supervising judge that when I was appointed and was in Manhattan, Judy Schonlin was the supervising judge of New York County. Not for purposes of seeing the cases, but just see the formula of how she asks questions. I remind litigants that a question is posed with the following first word of either what, where, when, how. Isn't it a fact? You can ask a question of an expert even though you're not an attorney. And I therefore give litigants the opportunity. But if indeed there's testimony that's been given, and there are questions that I have to it, or I want there to just be a review to make sure that I understand, I will ask questions to that. And certainly when I have experts who sometimes give me testimony that is contrary to logic or reasoning, I will ask a question there as well. But I would certainly be more mindful if there were two attorneys. Now, that puts me in a catch-22. Because if I'm ultimately making the determination, but you have an attorney there, but let's say, no one here included in this analysis, of course, it's a weak attorney who's not asking the right questions. And ultimately, the goal is to get an order that's fair and appropriate. What does a jurist do there? So that's also one of those lines that I don't like to cross. I'd like for the attorneys to do their job and function in a way that makes my job easier and not having to walk that line. But certainly, for the ultimate pursuit of justice and making a determination that's fair and appropriate, when a question needs to be asked, I'll ask.
Thanks. I want to move us along. I'm sure everyone has a lot of questions about this first half of the program. And again, just a reminder, if you do think of questions throughout the program, please feel free to write them on the index cards on your table and wave them around, and they can be brought up to me to ask. But I want to move on to enforcement and collection, which is the second broader topic that we're going to be covering today. We don't really want to turn this into an enforcement 101 class, but Magistrate Kirschbaum, I was wondering if you would just spend a few minutes sort of giving us an overview of the legal remedies available. In particular, we're going to today be focusing on the money judgments and incarceration, but if you just want to give us a quick intro to this topic, that'd be
Absolutely.
great.
So first, it should be noted that we have a statute, New York Family Law Statute 205.42, 0.43, insofar as the timeline for purposes of hearing and determining willful non-payment of child support. It is certainly that which concerns litigants as well as the court greatly in ensuring that those cases are fast-tracked and heard expeditiously. The statute requires a return date within the first 30 days and then a hearing within that 60 days. So sometimes you have litigants who are coming into court and they are saying, I've made a mistake. And they're falling on the sword and they're ultimately telling me that they need some time to gather money. And if I believe, because it's the first violation petition, that they need more time, and I ask the other side whether they're willing to consider, as long as the respondent comes to court with money going forward, would they be willing to withdraw the request for willfulness? If they say yes, it allows then for that timeline not to have to be complied with. And so as a result, someone who needs 60 days, 90 days to come up with money, then ultimately I'm going to give that to them. But if that's not a remedy that's useful, then we do have statutory authority to not only issue a money judgment based on a finding of simply non-payment. The statute is quite clear. It's not whether it's willful or not willful. You had the money, you didn't have the money. Did you pay, did you not pay? The case of Powers v. Powers is the landmark case with regard to violation petitions, and it clearly states, as does the statute 454, that non-payment of support is by definition a violation of support, to which the statute gives rise to 2A of that section, directing, and in the utilization of the word shall. The court shall enter a money judgment. It's not discretionary. Money judgment is issued, and if it has not been payable through the support collection unit, that the support collection unit should collect. Now, we see establishment cases, and we see a lot of post-matrimonial cases, and oftentimes in the matrimonial cases, the divorce judgment is entered. It's incorporating a separation agreement or stipulation of settlement, and as a result, there's no specific language that the order is payable through a collection agency. It's usually paid direct, or by income deduction order, which is predicated on someone having a job for which wage garnishment can take place. But if they come to court because they're filing a violation petition, presumably there is no wage garnishment, and as a result, they need enforcement. So I oftentimes will have the support collection unit who have already had a child support management system number assigned to it to start enforcing the order. And they have wonderful powers under social services law, similar to the powers that the court has under Article 4. But they're better at it because as much as I could sign an order directing the Department of Motor Vehicles to suspend a driver's license, a recreational license, a professional license, the fact is that the support collection unit can not only make sure that that happens, but give remedies to then allow for someone to be able to get a restricted license. Now, we have meetings and seminars, and oftentimes I speak to people in upstate New York, and they have great advantage of these suspensions of recreational licenses. When you have people who live in upstate and they like to hunt or they like to fish, and there are professional licenses issued by New York State allowing them to do so, they don't want to lose that license. There aren't too many people in the Bronx or in Springfield Gardens who has hunting licenses that I can suspend. But the support collection unit is there to ensure that people who certainly want to drive, even though they will tell me that it's not their car that they're driving, they want to be able to drive, and they want to be able to drive legally, that the suspension of the driver's license is utilized. Now, certainly for those cases for which either it is an egregious violation because someone has not been paying for a long period of time and brings in their financial information where clearly they've actually worked, so this is intentional. If they have counsel, well, then we'll immediately schedule a hearing. If they do not have counsel, I will usually assign an 18B attorney to them. Because if they had the money to pay the order of support, they would have paid the order of support. So as much as the custodial parent might say, well, they have a lot of money, they're just not using it, I err on the side of caution. I give them an 18B attorney. And I've seen enough cases that were deemed reversible error by making a finding of a willful violation where someone was not represented by counsel. It's important to understand that even though we are a civil court, when it comes to this particular nuance, this particular subject matter, we are not a criminal proceeding, but we are making determinations of contempt. And as a result, people have a right by statute to be represented by counsel. So I will ask, do you have the ability to hire a lawyer? I might sometimes come off that legal verbiage because people like to be talked to in a courteous manner and a respectful manner, but also as real people. So I sometimes use words such as, sir, are you getting what she wants this court to do to you? And sometimes it's purposeful to also have a visual. I'm lucky enough in my county and in my courtroom to have several doors. The door that I go in and out of, which is in the front of my courtroom. We have the court door in the back of the courtroom where people exit. And then we have a door to the side. That door ends up leading to an elevator going down to the Department of Corrections. And I give an illustration of those doors. so that they understand that there is another door that they can leave out of, even though that's not going home. So I say to them, do you want to go home today? I sometimes ask my court officer to open that door and to have them look inside to understand the implications of not paying an order of support. There is clearly, whether you want to suggest a misunderstanding of the process, or even if they understand but they don't really think this is serious, to get them on track to understand this is serious business, that children who are not being supported could end up being neglected. I sometimes invite them to go to a neglect part and see parents who are crying as they walk out of a courtroom because they're losing custody of their children to ACS. And I remind non-custodial parents, we can't take a child away from you who doesn't live with you already. But whatever you've been doing in not supporting a child, if the other parent, oftentimes mother, cannot provide financial support, and they are, therefore, not giving the necessaries to a child, that parent is subject to a neglect proceeding and an ACS prosecution. So even though you might not be prosecuted for neglect by ACS because you're a non-custodial parent, you still should be processed. And therefore, they have to understand the bigger picture and understand the implications of not supporting their children.
With regards to the bigger picture, I wonder, sure.
Bronx, Brooklyn, all violations. Harvard, child.
Thank you for that clarification. I'll just repeat it for the video for purposes of our viewers at home. Oh, sure.
Recommendation of incarceration by the Supreme Court that goes to the judge.
So just to repeat, basically the structure of the family court is changing a little bit, so they're opening up new child support enforcement parts in the Bronx, I'm sorry, I'm going to get it right, Brooklyn and Manhattan. So now, and hopefully in the other boroughs as well, and so all violation cases are going to be channeled to those parts instead of to the magistrate who signed the original order. And also a clarification that when there's a recommendation of incarceration by a magistrate, then that case will go before a judge because only a family court judge can actually order incarceration. Which does bring me sort of back to what I was going to ask you about in terms of incarceration, Magistrate Kirschblum, again, understanding that that final decision is not within your power, but when you think about the big picture, and you've mentioned that a few times already today, thinking about whether the order that you enter is going to actually be paid, if it's going to result in more hardship to the payor. Can you talk a little bit about how you think about recommendations of incarceration, keeping in mind, that, of course, the bigger picture that when someone does go to jail, they're no longer working and therefore cannot support their family and potentially, not themselves either. If you could speak a little bit about the big picture of willfulness.
So certainly, the judge is not going to hear the case unless I refer it. So therefore, even if a custodial parent wants a determination of or a rendering of an order of commitment order, unless I refer it, it's not going to the judge. So ultimately, the decision is first mine. And I look at these cases independently. For those cases where we have what I refer to as repeat offenders, where someone has constantly been brought in on a violation petition, and they've been found in willful contempt, and they haven't paid anything for years, and all of a sudden, based on that order of commitment being so ordered by the judge with then a purge amount, if they're able to come up with that purge amount quickly, well, that is some writing on the wall. And because, as I said, these cases are always coming back, so they'll then be able to purge, the violation is then disposed, and then they will go back to their old ways of not paying. So if I've seen a history where someone has been found in willful contempt and there's a purge amount, they might argue, well, that money that my mother had to pay the last time they don't have anymore, but I might test those waters. For cases in which someone has not been incarcerated yet, well, then it's based on the circumstances. I am always telling litigants, I'd rather you pay as much as you can to the order than pay zero of the order. And therefore, if I see zero being paid, to me, that is absolute willful contempt. Now, oftentimes you have to remember that these establishment orders were entered not based on one's income. It could be based on a imputation of income or an asset search. And ultimately, they truly believe in their hearts as a non-custodial parent, I can't pay this order. But if they're paying towards the order regularly, I think it's contrary to everyone's interest for then that order to stop. And the assumption that just because you're sending them to jail with that purge amount that they're going to come up with that money, we've had enough cases in which we've seen someone actually serve the 90-day prison term, or it's longer. Sometimes it's up to 6 months. So who benefited from that? But we want for litigants to be able to understand this is serious business. And if they think that they could come to court and simply get an adjournment slip, they do not believe it's serious. So we have the discretion to refer cases in and to then make a recommendation about time. Now, if someone says that they can work and will work, we can ask the family court judge to so order incarceration on weekends, that they turn themselves in at 6 p.m. on Friday and they should be released either Sunday night or Monday morning and go to work. And if you don't, then we will exercise the right to have the case recalendared, and then we will consider that instead of weekends, we will have a 60-day incarceration period. Whatever works. And if I believe that ultimately someone needs a lesson to be taught, then we give them a lesser time. But clearly, there's a lesson that has to be displayed, which is you're coming into court for a reason. You can't be cavalier about it. You can't suggest, well, she doesn't need it because she has a new boyfriend and he's providing her with X, Y, or Z. I remind parents of the fact that they are ultimately one of only two people who are ultimately responsible for the support of their children. Not significant others, but themselves. But of course, that sometimes has to be stretched because we have a lot of litigants who come into court and they tell me, and I've actually come home and asked my wife, can I quit my job and you support me? And she laughs and then tells me, go to work. But we have a lot of litigants who come to court who say, well, I have a girlfriend who's supporting me or a boyfriend who's supporting me. I don't have to work. And they don't want to hear that that significant other is responsible for the subject child or children. So I remind them, bring in your significant other so I could tell them that they're responsible, even though they're not. They don't want to do that. They don't want to bring them in. They do sometimes bring them to the courthouse, to the waiting area, so they could show up the original parents and say, look what I have now with me. But insofar as coming into the courtroom, nobody wants to be subject to an inquisition if they're not the actual litigant. But it's a demonstration. It's a lesson. And unfortunately, sometimes people are coming into this court system with a cavalier attitude of, they can't do anything to me. And so as a result, the order of commitments is a purposeful remedy. Now, there are colleagues of mine who I've had discussions with who don't believe in that process. There's also, and this is going to open up a can of worms, but there's a significant difference of opinion insofar as orders of commitments on cases for which the children have already emancipated by age. They've aged out. They're over 21, but you have a very large amount of arrears. Are we a debtor's prison facility? Are we making determinations on arrears only to the extent of not only issuing judgments so that people can then put liens and encumbrances on property, assuming that there's property, but utilize our court system to incarcerate those who owe for the past? And some believe philosophically, but the money is for the child. Child's already aged out. Child's not in the custodial parent's home anymore, so it's a repayment to the parent who was raising the child. And others believe that, well, but they're entitled to this. And if this is the only justice that could be provided, then it's a remedy that the statute has not clearly defined as only for existing orders and not arrears-only orders, and therefore believe that it's a tool that should be utilized. And then ultimately, once we make that recommendation, it's up to the family court judge to make the so order.
Just curious, how many times in your experience have you seen recidivism after commitment terms? So you say that you use commitment mostly as a stick to let people know that you're serious. If they actually go in and serve that time, do you often see people again?
Yes. And one of the things that we have in our system, in contrast to every other civil court that has a filing fee, is we have a process where we are a people's court. So I've actually seen cases for which the very day after the order of commitment has been served, The petitioner comes back to court and says, well, now he's out, so now I want him to pay, and files another violation petition. And with those, I would certainly have a different posture. But for the ones where someone has served time and then should be able to go back into the work world and has and simply not paid, I would certainly utilize the system once again. For those who are having difficulty in finding work, and certainly having a criminal record impacts on one's ability to find gainful employment. That's why we have the Support Through Employment program, the STEP program, that helps for those non-custodial parents who need a job. And oftentimes they can help people who have a felony conviction. And I will therefore adjourn a matter, holding aside the issue of willfulness, because STEP usually needs about 2 to 3 months. I'll put them in that program, which the statute allows for me to put a respondent into a placement of an employment program, and I'll get a participant evaluation to see what have they done. Have they attended? Have they been compliant? Have they been helpful to their own hopeful expectation to be able to be gainfully employed? And if I find that they're a lost cause, well, then ultimately they're going to spend a lot of time in my courtroom.
Yes, a question.
We have a program in Brooklyn, ran and designed to whose sole job is to apply for grants. Okay. At the city has been very successful.
Mm-hmm.
Brooklyn. Now it's from the Center.
So for those who didn't hear, the Center for Court Innovation has a grant now for a caseworker to be in the violation part to potentially help respondents get gainful employment because, again, as I'm sure many of you are familiar with in terms of the interaction with the criminal justice system, breaks in employment for incarceration or that kind of record can also make it difficult for someone to be employed in the future. Yiro, I want to switch it back to you before we open up the floor for questions and just have you talk a little bit because in our imputing income section, you talked about doing asset searches in order to find assets to show that there was income there when someone claims there is not. Can you talk a little bit about asset searching now in the context of helping someone who has a money judgment execute against that any assets that you might be able to find?
Sure. The asset search methodology that Kroll applies in terms of executing money judgments for divorces is really no different than the one that we apply in any sort of enforcement of judgments and in money judgments for all litigation. So we'll typically do a full background check. We'll look at all public records. We'll look at social media. We'll look at property, vehicle registrations. Sometimes we'll do source inquiries and surveillance, and all of that will paint a fuller picture of the financial situation of the adverse party post-judgment.
And do you also assist in executing those money judgments, or is that then left to the attorney and the sheriff to handle that once you pass over the searches?
I think that's the attorney.
Okay. Great. Well, we left a long period of time for questions. We've gone into that time a lot, but I do want to open it up before 2 o'clock. Did anyone have any questions written on index cards that they wanted to hand? Oh, Martha has some. Oh. Thank you. Oh, great. Okay. All right. So I have a question here about add-ons. I assume this question is for Magistrate Kirschblum. How do you handle cases when one party won't pay for add-on expenses, camp, preschool, not funded by the state, and others, when the other litigant consistently declines payment?
That's a good question. So for the matrimonial cases for which there's a stipulation incorporated into a judgment or a judgment divorce that has these add-ons as a so order, they are enforceable. And as a result, just as basic orders of support should be collectible, so should these add-ons. So oftentimes with those types of cases, the first thing I do is I order the support collection unit to collect. And I put all of the different elements of the order of support, the basic order, and the add-ons. I quantify them, and I ultimately tell support collection unit to collect. And if there's a failure to remit that payment, then one is subject to the wrath of the support collection unit insofar as losing their driver's license or having their credit impacted by the support collection unit not receiving that money. Now, for the order of support that parties are coming to court for an establishment case, and they're asking for add-ons, there are certain add-ons that are statutorily required, such as childcare. If someone is clearly, as a custodial parent, gainfully employed, and they have a childcare add-on, I will then allow for them to testify as to that childcare expense, and then I will prorate that based on the respective incomes of the parties. Which goes back to the earlier question of, well, how do you determine the incomes of the parties? Well, hopefully they're both W-2, and you can easily figure out the calculation. Sometimes not so easy. But ultimately, that's the goal, to work out a determination of the respective incomes of the parties and make a determination accordingly as to that basic order of support as well as the add-ons. There are certain requests for additional add-ons that are not statutorily required, but are statutorily authorized, such as private education, 413 1C6, 1C7, college, private school, and to that we look at past history. Have the children been in private school before the parties separated? Did the parents go to a private school? Did parents go to college? What is the responsibility to one who is raising children and the child ends up in a private school? College, also complicated, because as much as oftentimes children are attending local colleges and therefore they're still living in the custodial home, oftentimes they're also traveling elsewhere and living on campus at a collegiate facility. Should a parent, a custodial parent, receive basic support for the upkeep of a child who's not living in their home and yet at the same time receive not only for the actual course load but also for the campus, which includes the living, it includes a meal plan, when presumably the basic order of support should be including those things as necessaries because of the budget of a household. A little more complicated. I take them on a case-by-case basis. But ultimately, the function is to enter an order of support based on the statute with discretion. Now, I've had situations where parents, custodial parents, have come into court and said that upon dismissal from school, the children have gone to a ballet class, or they have gone for swimming or karate. And the first thing that I will look at is this in addition to or in place of a child care facility? It should not be the responsibility of a parent to ultimately have to work and provide for a household and worry about the care of the children without there being some responsibility on the non-custodial parent's part as well. So how do you define childcare? Does it have to be a licensed facility? And is the licensed facility having to be a daycare or an after-school program at a school? So oftentimes parents are determining that better to send the child to a program after school because they're working. And if that's the case, then I would consider that as an alternative to childcare. Then you have this more complicated situation of that babysitter who's being paid cash in their house, and how do you determine ultimately that cost? And oftentimes, the best evidence rule is to dictate. Bring them to court. Let them testify. If you want this to be an add-on, let me hear it from them, and most importantly, for the other side, because ultimately you don't want to make rulings and the other side saying they're on their side. So allow them to also question. I will ask, oftentimes, the non-custodial parent respondent, do you know where your 6-year-old is going after dismissal from school? Well, mom is working a conventional job, or dad, for which they're showing a W-2 income, illustrating, based on their pay stub, 40 hours of work, conventionally 9 to 5, and the child's dismissed from PS whatever at 2 o'clock. Where are your children going? If they don't have any idea, then I'm certainly even more inclined to providing for that add-on. And if they do know, and they suggest that someone else is watching the child, well, then prove it. One of the things that I constantly have to remind parents is, as much as you might actually do watch a TV show where people are coming to court and they're just saying anything after raising that right hand, evidence, which I now know in several different languages, Spanish it's evidencia, I remind them this is something you need. Do not just tell me this. Prove this to me. And if you can, I will utilize it in making a determination, once again, fair, appropriate, and just.
I have a personal follow-up question. Oh, go ahead.
That was actually my question.
Oh.
Just like a follow-up to that.
Mhm.
If there's legal joint custody, and the parties argue as to say a young child, like a 2 or 3-year-old, oh, I don't like that daycare, that preschool. How do you deal with the actual cost? I'm in Nassau County. Of the cost of what you would assume is the average or cost for that.
Let me just repeat the question for the video. If the parties are disputing about whether the daycare or babysitter care provider is appropriate, whether the cost is appropriate, whether they like the daycare center, how do you deal with that?
What cost?
Or the cost analogy?
So the actual choice is one that parents have to make. The court's function is not to parent parents or to dictate to them what facility they should use. I'm going to digress for a minute and then I'll get back to the question. When I was presiding in Manhattan, I learned about the rich and the uppity, and I was fascinated by their lifestyle and the amount of services that not only they are providing for themselves, but also for their children as just a standard of living. I learned about a school system that is tens of thousands of dollars per year, and in the environment that they live, it's appropriate and it's reasonable. And then you end up somewhere else where you have people who are conventional wage earners. And therefore, it's not a question of the choice of facility, it's about the cost. One parent, even if there's no joint custody, and one parent is the sole custodian, unless there's an order that specifically states that they have absolute right to make unilateral decisions about everything, that there should be some wisdom and also some type of communication with the other party. If a parent is coming into court and saying that they have a babysitter or a child care center for which they're being charged $2,000 a month, and the other parent says it's unreasonable, I will say to them, that's fine. This is the address or the location for which the child lives. Find somewhere else. Bring back evidence of a more appropriate child care facility where the cost is more appropriate. And I will utilize that cost, and I'll balance it. It's the same thing when it comes to my ordering unreimbursed medical and dental and other costs. If someone is ultimately going to have such an order, and remember that it's based on proratas of people's income, but what's interesting is that oftentimes you find custodial parents who have a responsibility for, say, 10 or 15 or 20 or 25% of the prorata, while the other parent has the other 85, 75 or whatnot. And yet the custodial parent's making a unilateral decision. I want to use that dentist on 71st Street and Park Avenue, for which braces are not $5,000 or $6,000, it's $15,000. And he has to pay 85% of it. So it's a question of reasonableness. And if a parent can come to court and is challenging the actual cost, well, then do your due diligence, come to court, show me what the aggregate should be. And just as you was talking about for purposes of imputing income, what the aggregate is. I've seen literature on the aggregate incomes of almost every occupation out there that attorneys will utilize in saying, well, this person does this for a living, so in the United States, conventionally, this is what they should be making, and more importantly, in New York City, this is what conventionally they make. But we know that that's not the case. Not every attorney makes the same amount of money. Not every corporate attorney makes the same amount of money. Not every family law practitioner makes the same amount of money. But the fact is that it should not be borne by one party alone. And if one party is making a unilateral decision and then shifting that cost to the other, in my courtroom, that's an unjust determination. So I give the opportunity to the other parent to come back to court with something that's reasonable, recognizing that there is a responsibility for that child care. Children cannot be unattended. And if there's something that's more appropriate, show it to me, and I might just use it.
Okay. I'm going to combine a couple of these questions, just keeping an eye on the clock. I know, Magistrate, that you have to go promptly at 2.
I closed out the part, so I'm available a little bit more if you need.
Great. Well, thank you. I'm still going to combine these questions because I think they overlap a little bit. I have a question from one person regarding, in fact, you just raised the Department of Labor statistics for the average income of someone. So this person is asking, would you consider Department of Labor statistics? It sounds like you're saying yes, but So maybe you could expand a little bit on when you find Department of Labor statistics compelling. And then I have another question regarding whether you do or consider analysis of income by an expert in career analysis or a career expert.
So if somebody has a conventional job and a W-2 income and a pay stub, I'm not going to start challenging them as to why they're being paid that sum of money when the Labor Department says, you should be making this. Nobody wants to be told, you should be making a lot more than you are right now. The chairman just left, but I might just ask that question of OCA. Why am I not making more? But the fact is, ultimately, that's not a question that I'm going to pose. If someone has a conventional job and there's clear, convincing evidence of income that's being reported, and you have to remember, what is a W-2 and a pay stub? It's not only a representation of one's income to the court, since usually they're not in court, but it's also to the insurance departments, as well as the IRS and New York State Department of Taxation and workers' compensation and unemployment insurance. There's a representation being made. This is what we're paying our employee, and therefore this is what their income is, gross and net. Now, if someone's coming to court, though, with undocumented or with documentation that shows that they either have a proprietor interest in a business and therefore they're paying themselves, or the alternative that they're being paid by a brother or some other family member and they're receiving a 1099 and it's disproportionate, I absolutely would look at statistics and make a determination, what should they be earning? Will I tell them to their face, you should be making this? No, but I will utilize that, in fact, as a factor, and also utilizing the other elements, the financial disclosure affidavit, what their expenses are, what their reported spending habits are. Going back to the passport, are they traveling? Can you travel abroad when you're making $8,000 or $12,000 per year? And who's paying for your tickets? And what exactly did you do insofar as your lodging? So the answer is yes, I will utilize it. Mm-hmm. But if someone has a reported income that's credible, I usually opt for that.
Okay. You're sort of coming off of your comment of who's paying for the lifestyle that you have. I know that we talked a little bit at the end of the enforcement section about if someone is living with a new partner, that you sometimes sort of fake them out, for lack of a better word, and say, bring that person in and I'll tell them they're responsible, but you say they're not actually responsible for a child that's not theirs. As a follow-up question, does that change if or when he, the father in this case, actually gets married? And in that case, if there's a legal marriage, do you then take the spouse's income into account when either calculating child support or deciding on enforcement?
A spouse has a responsibility to maintain themselves, and there is, under New York State law, a responsibility to support one spouse. So if parties separate, they can immediately come to court, either in a matrimonial court or a family court, and be awarded an order of support if the other parent is the other spouse is an earner. So the answer is technically yes. I'm more concerned with the picture of a child who's not being supported by that person who decides, I don't have to work because ultimately my spouse is taking care of me. And for those who have a lifestyle where they're living in a home while the custodial parent's living in an apartment and doesn't have enough rooms for all of the occupants, where they have to worry about how they pay for food while the parent, the respondent, is not gainfully employed, but never having to worry about going to a restaurant or going out for entertainment. And it's interesting how oftentimes you look at these financial affidavits and they do disclose all of their expenses, including entertainment and cable and cellular phone, even though they have no income. And so therefore, sometimes I will utilize that affidavit or testimony in determining what exactly is being spent on you. And I will then multiply that number on a monthly basis by 12 and impute that as income. Now, ultimately, you have to do a lot of different analysis. And magistrates sometimes have to be accountants, where you utilize all of this. Now, the endeavor and the motivation, as well as the ultimate goal, is not to come up with the highest order possible, but the fairest order that's possible. But if someone is going to be maintained, it is no different than being supported by a parent and having a lifestyle where they do not have to work. Why would anybody go out and get a $10 per hour job if they can have the same lifestyle without the $10 per hour job, unless you're motivated for some reason or another. But those parents still have responsibility to financially support their children. If you don't have enough to pay the order of support and you're not working, find a job. And I'll enter it as a temporary order of support. And luckily for those cases, but for issues of standards and goals, I'll give it a lengthier adjournment. Find a job. Get me a pay stub. I oftentimes use different types of lines from movies and TV shows. I use a lot of Jerry Maguire. Show me the money. Or help me help you. Ultimately, you want me to enter an order of support that you say you can afford, where you're showing me zero right now, and the order is not going to be zero. So if you want an order that you can pay, show me the money.
So you mentioned about being supported by family members. I have another question here. What effect does it have in an enforcement action if you're presented with evidence that the respondent has transferred ownership of residence to a family member or a business entity, but if he continues to reside at the house?
Everything. If you ultimately are transferring assets and you're not paying your order of support, I will test your family. Your family is not a litigant. They are a non-party, but by you transferring property to them, you are bringing them into this equation. And as a result, I will indeed utilize that as a determination of not only trying to reduce one's assets and earnings for purposes of not paying an order of support, but I will hold them to the test. And oftentimes, I will say, if you want me to understand this, then bring them to court. Call them as your witness. It's important that they understand that this is a court proceeding. And therefore, even if they're not represented by counsel, they have the responsibility to prove this clearly and convincingly. Now, certainly for an enforcement petition, I will tell the attorney, whether it's private or assigned, I want to see the family member who they did this with. Otherwise, I will utilize that failure to produce that person as a negative inference and potentially enter an order of willfulness as a result. So I absolutely will utilize it, and I will be interested to know what exactly is the reason and what exactly is the present status. And if someone's still living in the home, well, then I'm going to test the family and send it in for a order of commitment and see whether that purge amount will be paid. And oftentimes it is.
I have a few questions that are along similar lines, so I'm going to ask them as one large question. Forgive me for those of you who wrote these cards out. First part of the question is, what tips do you have for those parties who cannot afford the services of a company like Kroll to prove imputed income? I'm actually going to field that one because I want to say that if you end up taking a support case through her justice pro bono, then Kroll has generously been working with us, and oftentimes if Kroll is needed or a forensic firm like that to do some of this work, then we can actually get Kroll or another financial firm to work with you pro bono as well. But then I guess for those of you who don't take cases through her justice, what tips do you have about proving imputed income? Do you, as a jurist, Magistrate Kirschblum, demand additional info from litigants or appoint neutral experts to assist you? And also relatedly, if the respondent work history shows a consistent pattern of underemployment, what evidence would be compelling to you to then have some imputation of extra income?
So certainly for establishment cases, I expect for someone to come to court with clear and convincing evidence of income. And when they don't, I will utilize the other statutory options insofar as either imputing income to them or utilizing a needs-based order. Is it helpful for a petitioner who's seeking an order of support to have those types of resources available to them? Of course. But I can't do their work for them. And I cannot tell them what they should do in finding. But they can be resourceful. And oftentimes, pictures from camera phones are helpful. But the phones also have to be in a non-operational system. So ultimately, these cases will be adjourned. Print your document. And then I will allow for the other party to explain. Attesting witnesses. People who can come to court as a corroborating affiant for purposes of being able to show that someone is doing something or living a lifestyle that is contrary to their alleged non-income or non-employment. bring someone to court and let them explain to me what they're saying. Now, obviously, you have to take that in context. Every petitioner has a sister or a mother who wants their daughter or their sister to get more. So just because they're coming to court with such an affiant, why just accept that testimony? Well, I saw so-and-so doing such and such, and therefore they clearly have more than they're saying that they have. So you have to take everything with a certain context. But for those who are looking for assets, there are things that one can do. And one of the most helpful things that they have is the support collection unit, because the support collection unit can do an assets inquiry. So you can utilize their services, which are free, for purposes of having them assist you insofar as being able to inquire of assets, look at past tax returns, driver's licenses, etc. Bank accounts, they do execute on bank accounts and put liens on bank accounts, intercept tax refunds, and allow them to do their services and being able to provide. But I have to be careful, and therefore attorneys have to understand that if it appears that the court is biased to the custodian, it creates such a unfortunate circumstance, not only insofar as determining the result of that case on that particular day, but for the rest of the children's unemancipated years. If a litigant is going to believe that it's a one-sided process, they are going to come to court hostile, argumentative, non-responsive, and uncooperative. And we don't want that either. The purpose is not to have people violate the orders and being punished for violating the orders. The purpose of the court system is to be able to provide a remedy where people can receive the amounts that they should be receiving for their children. Not possibly what they want to receive, but what they should receive. And sometimes that's a big difference between the two.
I have a follow-up question regarding add-on expenses and in particular daycare providers. You mentioned that the best evidence is to get that person in your courtroom. How would you weigh the following special considerations? First of all, if there's a claim that there's domestic violence in this relationship and actually the daycare provider is confidential and it's unsafe for him to know where that daycare is, would you consider some other form of evidence of the daycare expenses? And secondly, even without a domestic violence allegation, if a daycare provider is, for example, just one person running a center where they have 12 other kids, are you going to take into account the burden on that person and all the other families if they have to close the daycare to come into court to testify? And how might you alleviate that burden if you decide to ask them to come in?
So if there's a history with orders of protection and exclusion orders, and there specifically is orders that do not require disclosure of information, I'm not going to require disclosure of information. But I am going to need to see proof that the custodial parent needs the child care. I can't tell you how often I have cases in which there's a child care affidavit, and when I ask about their tasks, the child care is being provided in a household. Well, they're also doing cleaning, and they're also preparing for certain other types of things. I'm not suggesting meals is not an appropriate child care provision, but other things, specifically cleaning. This isn't a home attendant or a housekeeper. It's a child care provider. And when the custodial parent has more than one child, and there's only one child who's the subject of the proceeding, then I certainly have to take into account what exactly is the factor that this child makes up of that. Meaning, if we have 4 children and we have a babysitter who's watching all 4 of them, will I utilize a 25% per child analysis? Well, that also depends. If you have a baby and the child care provider is a live-in and providing care for the baby at all times, then I might not utilize a 25% per child analysis. The same way is when it comes to health insurance costs. When you add a child to a family plan, there's no additional cost to the family plan. The family plan is the plan. And whether you have one dependent child or you have many, the family policy is the policy. The cost is the cost. So if I see that there is a change to the expense, then I might utilize that difference between the initial expense and the subsequent expense. If I find that it's the older child that's being sought for an order of support and it's a baby who is also in that household and that baby is being provided for by the same child care provider and for more hours, I might utilize that in holding to a lesser cost. But it's a case-by-case basis. As to the domestic violence and the rights to privacy. I certainly do not want to violate that. But there is a line. The fact that you want to keep for security purposes that privacy is your right. But the right to challenge an expense that you're seeking reimbursement for is also a right. Someone has a right to seek clear and convincing evidence of an actual cost being expended, how, where, what, and whether it's real. And to that, you do have to make a prima facie case. But I'm certainly sensitized to the domestic violence, and therefore, when it comes to addresses and certain other disclosures, I will certainly allow for that to be redacted if it's in written form, or to have that question and an objection to that question being sustained.
I know that we are running a little bit past time, so anyone who needs to go, feel free to leave. I won't take it poorly. But we do have some other questions that I hope to get to. I have a question here about the income cap in the statute. When will you consider awarding child support above the cap, and how far above will you go?
It's 2:10. I could speak about that for about 6 hours. I did some very high-income cases. I had practitioners who came into my court when I was presiding at 60 Lafayette Street who told me, but the matrimonial judge at 60 Center Street has a $250,000 or $300,000 cap. And I asked them to, first I would see Judge Cooper at times and ask him, does he have such, and he would deny it. But ultimately, the answer is there's no statutory authority to suggest that there's a cap of anything other than Cassano. So the first $143,000 is to be utilized. To that end, it ultimately then, as the case law supports, a question of beyond the cap, what is appropriate? I look at standard of living. I look at household. I look at whether these parties ever lived together and what ultimately was the costs that were being borne at that time. And then, if we have a case which is a paternity case and the non-custodial parent is a high earner, well, then certainly I will utilize that in making a determination. But there is no fixed number. And I certainly would not, in a public forum, say, I do not go over this and apply 17% only to this first amount. I think that that is inappropriate to do, and therefore everything should be considered on a case-by-case basis. But this leads to a different question, which is discovery. When you have a parent, and I've had some celebrity cases where the attorneys for them came in and said, we don't need to disclose income. Whatever the child needs, we're ready to pay for. So why do you need to know whether it's $100 million or $500 million or $1 billion? I had a litigant who owns his own island in the Caribbean, and when it came to their financial affidavit, they wrote for purposes of income in excess of, and wrote $100 million because they didn't want to disclose the full amount. Do I really need to know whether it's $500 million or $1 billion for purposes of determining what this child should receive? The answer, of course, is no. And that's why the statute allows for there to be specifically certain information. Of course, when you have celebrity cases, you also have media that wants access. And do they have a right to access of this personal information? When ultimately, what is the function and what is the issue here? Providing for a child. Now, that leads to one other digression that I'll mention. What happens when you have a paternity case with a high-earning respondent and they have another family, whether they're still living with them or not? That family has a standard of living. Is it appropriate to suggest that the subject child should be entitled to the same standard of living? I'm always amazed that you can have children of your primary relationship who you're sending to Montessori schools and expending all kinds of money, but now you've had a baby and you want them to be in the public school system. Why should that be? So even if there hasn't been a standard of living established for the household, what type of lifestyle does this respondent's other family have? I believe that's relevant to the extent of at least an analysis of what could this child be entitled to.
Following on from that, the lifestyle analysis, I have a question about if the petitioner, so the custodial parent, claims that the funds that they're receiving are not sufficient, but has a lavish lifestyle, funds to travel, et cetera. I guess this question is really getting at sort of the other side. If the custodial parent is living a lavish lifestyle, how can that be used against them?
It shouldn't be used against them, but ultimately, as I will remind both parents, they're both still responsible for the child. So there is certainly an analysis of utilizing the respondent's income and making a determination of an order of support and possibly capping it at the first $143,000 worth of income. If the child's needs are being provided for, then the question is the provisions for the child being provided for by the petitioner, or because the petitioner has actually taken on a relationship where they have a very large earner who's providing for their own expenses. Again, a case-by-case basis, but I constantly remind both parents, and sometimes I use celebrity names, that if the mother is so-and-so, that doesn't mean that you do not have a responsibility, directing my attention to the respondent, of not having a responsibility to support the child. You still have a responsibility to support the child too. This is both of your children. And at the same time, if there is no income from them, they should still get a job. Now, I'm not going to force a custodial parent to get a job when they have young children that they're tending to. But if they have young children, but they also have a child care provider, and they're going to the spa all day, then I might utilize an imputation of income to them. The one thing that's really important is that the statute and the legislature has made a determination not to analyze just the non-custodial parent's income. I think that it's important that everyone be reminded that when the drafters of the statute asked for, or not asked, but directed compulsory financial disclosure, it wasn't for purposes of just getting income from the paying parent and utilizing it and making a determination of support. Even insofar as the $143,000 worth of income, it is a combined parental income. So the mother or father, whoever's the custodial parent's income, is also being factored. And as a result, that first $143,000 could in very large part be the custodial parent's income. So how are you utilizing that as a factor? Well, the statute says you have to, because it is on the first $143,000 of combined parental income. So that's where you look at the proratas. You look at both parents' income. And if by chance the custodial parent's income is 90% of the combined parental income, and the non-custodial parents the other 10%, well, I usually would still hold them to the 10%, even if the income of the custodial parent is, say, $250,000 and the income of the respondent is $30,000. I might still hold them to 17% on that $30,000. But once again, with the footnote of every case is different. So what I do in one case might not be the circumstance of the next.
I just want to wrap up with one more short question, and I apologize if I didn't get to all of the questions that were submitted, but back to enforcement. We talked a little bit about using the support collection unit powers. If the support collection unit is involved in a support case, can the judgment creditor's attorney also pursue their enforcement remedies, such as an information subpoena and a restraining notice, et cetera?
Absolutely. If the support collection unit is involved, but they are not successful in collection, especially for an enforcement case, parties are not limited to their abilities at the support collection unit level. If you have counsel who has the remedies with the utilization of services that are beyond the support collection unit or duplicative but more successful, you have a right to utilize them. Absolutely.
Great. Well, this wraps it up. Thank you so much to both of our panelists, and thank you again to Proskauer and our co-hosts, and I hope this was useful. It was certainly useful for me, so thanks and have a great day.